Are we having counsel that's ready?
Ready.
Are you ready, Mr. Schmidt?
Ms. Smith.
Mary Lou Beth Smith, CR 1739. Motion to revoke.
Judge, we're still negotiating with the state. I'd ask for another setting on Ms. Smith.
How many settings has she had on her motion to revoke? You know, Mr. Schmidt, is this first?
Second. As far as I've been involved, we had the first appearance right after her appointment and we set it today in the hopes to have it resolved.
Okay.
So it's not too.
Court will set Ms. Smith for a final hearing on her motion to revoke on March 30th at 1:30. Okay. Pretty ready on that, Mr. Schmidt.
The only one I have left over here is Mr. Hogg. He's in the special tank. I filed a competency motion this morning. And so what I'd like to do is have that ordered and have him evaluated before we call him up. Apparently he's supposed to be brought separately, rather than bringing him. I'm just gonna go meet with him if that's all right with the court. Etc.
Right. Court will grant the motion to have Mr. Hogg evaluated for competency. And the court will waive his appearance in court today. We'll reset this to, let's see. We'll reset it for status on competency evaluation. March 28th. 1:30.
Thank you. Last but not least, that one of my clients that was scheduled this morning, called Ms. Tabor, and that she was supposed to appear at the courthouse at 1:30. I'll get away if that's okay, and hopefully get Mrs. Ashley Dover.
Yes, Ms. Dover is here and she's waiting out in the hallway.
Yes, sir. I'll be over, Greg.
All right, thanks, sir.
Judge, before Mr. Schmidt leaves, was Mr. Collier reset? There was some discussion about whether that was going to happen. I just didn't know if it actually did.
Yes, the court granted Mr. Schmidt's motion for continuance to Mr. Collier, and I put in the reset notice, which you should have gotten e-file. I believe I'll reset that until March 30th, the next evidentiary setting.
Thank you, Judge.
Mr. Manning, you ready?
Yes, sir.
Are you ready on first?
We can start with Mr. Jones, Dennis Jones.
Dennis Ray Jones, CR 21328, 2021-541, 2021-540. Understanding this is going to be a plea today, is that correct?
Yes, Judge, and just a clarification, if you look on your docket, this shows for some reason that it's a motion to adjudicate. This is not, in fact, a motion to adjudicate, but it's in fact a initial plea on the felony, as well as resolving the initial cases on both of the misdemeanors as well.
So neither misdemeanor is a motion to revoke?
No, Judge.
All right, thank you. All right, can you go ahead and give me the terms of the plea?
Yes, Judge. In CR 21328, state agrees to abandon the enhancement paragraphs and proceed on the state jail felony with a agreement for punishment assessed at 7 months state jail, the fine of $900. Court costs are $290. Reimbursement is $35. The sentence will run concurrently, as well as he has 87 days credit. And Judge, I will note, Mr. Jones and I had a discussion about his time credit, and there was some time that he was in jail prior to being appointed counsel that he was on a PR bond for the felony, but in new offenses. I requested the state give him, out of equity, give him those additional days, but they declined, as the law does not require them to give those days. Additionally, in 2021 541, that is an assault causing bodily injury, family violence. Upon a plea of guilty, punishment is to be assessed at 86 days in county jail, credit for time served, $100 fine, family violence fine, 1245, the violation of protective order in 2021 540. And as I said, he does have 86 days credit, fine of $100, cost $270, and reimbursement $530.
And Mr. Manning, what was the fine amount on the felony cost? I think you cut out, or at least I couldn't hear you.
$900.
900.
That's correct, Judge. There's a total of both fines to 1,000.
Okay. All right, Mr. Jones, if you'll raise your right hand. Do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
All right, thank you. You can lower your hand. Just make sure you speak up loudly and clearly for me. Your name is Dennis Ray Jones, is that correct?
Yes, sir.
And Mr. Jones, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
Did you say no?
No.
Okay. In this case, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with him as your attorney?
Yes.
You feel like you've had enough time to talk with Mr. Manning about your case and have all of your legal questions answered?
Yes.
Is there anything about the paperwork that you've read and signed today that you do not understand? Mr. Manning, do you believe Mr. Jones to be competent?
Yes, Judge.
And you've explained to him his rights regarding each one of these cases, the plea agreements.
I have, Judge. I've also discussed defenses for certain parts of these charges, and he understands that we're waiving those in order to go forward today.
Okay. And do you believe that he is entering into the plea agreements intentionally, knowingly, and voluntarily?
Yes.
Okay. All right, Mr. Jones, you heard Mr. Manning read the plea agreements to the court. Is that correct?
Yes, sir.
Is that what you're asking the court to approve today?
Yes, sir.
All right, Mr. Jones, you are charged by indictment with a state jail felony offense of theft of property greater than or equal to $2,500 but less than $30,000. A state jail felony carries a range of punishment, which must be not less than 6 months confinement in state jail or more than 2 years confinement in state jail. I see here that the plea agreement would fall within that range of punishment at 7 months in the state jail. Also, you could not receive a fine of more than $10,000. And I see here that the fine is $900. With regard to the assault causes bodily injury of a family member, a class A misdemeanor, that has a range of punishment of confinement in the county jail not to exceed 365 days and a fine that cannot exceed $4,000. And I see that the plea agreement would legally fit within that range of punishment at 86 days and a $100 fine. Understanding the plea agreements, understanding the range of punishments, Mr. Jones, how do you plead to theft of property, $2,500 to $30,000, and assault causes bodily injury of a family member, class A misdemeanor? How do you plead to those crimes?
Guilty.
Are you pleading guilty to each one of those crimes because you are guilty of committing each one of those crimes?
Yes.
Mr. Jones, has anyone threatened you, forced you, pressured you to plead guilty to either crime today?
No.
Court accepts the defendant's plea of guilt in each case respectively. Mr. Manning, any objection to the evidence supporting the pleas?
No objection to stage one in both causes.
Stage one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close in both causes.
Anything further from the defense?
Judge, just briefly, I did take over this case from Mr. Sawyer that was on the trial docket. I sat down, I was able to go over the case and its defenses with Mr. Jones, and also renegotiate a plea deal with the state to resolve this matter. Judge, I'd also just make note that we also have executed a 1245 form in this, and that'll be part of the plea paperwork that's sent over.
Thank you, Mr. Manning. All right, Mr. Woodwhite, can you give me the evidence to support the plea?
Yes, Judge, in the theft of property case, Grand Saline Police Department is talking to a unrelated, I don't know the relationship between Mr. Jones and his driver about expired registration. When she states she has to go inside to get her ID, which he lets her do, while that is occurring, Grand Saline sees the defendant put a meth pipe on the counter through the open door. Grand Saline commands him to bring the meth pipe out and discusses and notices that in the garage there is a motorcycle. He asks about it, and it's clear that the ignition has been punched. Defendant says that he traded for the motorcycle. He didn't think it was stolen, but when he got it, the steering was locked, so he punched the ignition and was able to hotwire the motorcycle. In the family violence charge, Grand Saline Police Department is called out for a disturbance, made contact with the victim, who states that her boyfriend this was not my case, Judge, so if you'd give me a moment. I'm sorry, the victim states that her brother grabbed her by the shoulders and attempted to pull her out of her vehicle. They were in a fight over her boyfriend. They speak to defendant, and he says that the assault did not occur, but they did have an altercation. Jones was taken into custody, and they observe minor injuries consistent with the victim being grabbed.
Thank you, Mr. Woodwhite. Any objections, Mr. Manning?
No objections, Judge.
All right, then, based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Jones of this offense. So each one of these offenses, court will follow the plea agreement that the defendant has reached with the state in each case. In CR 21-328, court hereby convicts Dennis Ray Jones of theft of property, a state jail felony, $2,500 to $30,000, assesses his punishment at 7 months confinement in the state jail, orders him to pay a $900 fine, $290 court cost, $35 reimbursement fees, and gives Mr. Jones 87 days credit towards his sentence for the time that he has spent in jail on this cause. In cause number 2021-541 to the charge of assault causes bodily injury of a family member, court convicts Mr. Jones of that offense, assesses punishment at 86 days confinement in the county jail, orders that he receive credit for 86 days of time served, orders that he pays a $100 fine, $270 court cost, $530 reimbursement fees, and the court dismisses under section 1245, cause number 2021-540. Mr. Jones, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Step over with Deputy Everett to be fingerprinted. Who's next, Mr. Manning?
Judge, if we can do Mr. Gutierrez, Damon Gutierrez.
Damon Jacob Gutierrez, CR 21-69. Is this a plea today, Mr. Manning?
Yes, Judge.
All right, if you can go ahead and give me the terms.
Judge, this is going to be proceeding on adjudication for possession of controlled substance, penalty group 1 to 4 grams. Mr. Gutierrez was placed on probation back in April of 2022 with a date of offense of June 14th, 2022. He's pleading true to the motion to adjudicate. As I said, that is a 3rd-degree felony. And upon a plea of true, the state recommends that the defendant's guilt be adjudicated, community supervision revoked. Punishment is assessed at 3 years TDC with the balance of financial obligations. His financial obligations include a fines of $2,000, restitution amount of $180, court cost of $90, and reimbursement of $275. He has credit time of 179 days, and this sentence will run concurrent with any and all other sentences.
Are there other sentences that Mr. Gutierrez is serving?
Yes, Judge, and I just remembered. Oh, never mind. That doesn't apply to this case.
All right, and does your client waive the formal reading of the state's motion to adjudicate and revoke?
He does, Judge. We will review that.
All right, Mr. Gutierrez, you just go ahead and raise your right hand. Let me swear you in. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, lower your hand. Make sure you speak out loudly and clearly so the microphone picks you up so that I can hear you. Mr. Gutierrez, you are represented by Mr. Manning. Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you feel like you've had enough time to talk with him about your motion to revoke and had all your legal questions answered?
Yes, sir.
Is there any you have to speak up or I can't hear you? Okay.
Sorry, Judge. It's really loud over here. A lot of yelling going on back behind us.
Okay, well, I mean, I just can't hear him at all. So, all right. So, Mr. Gutierrez, you've had time to read the state's motion to adjudicate with Mr. Manning. Is that correct?
Yes, sir.
And is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
All right. So, Mr. Gutierrez, you appeared before the court on April 14th of 2022. You pled guilty to the possession of controlled substance, penalty group 1 gram to 4 grams, a third-degree felony. The court heard the evidence, found that there was enough evidence to convict you, but the court deferred a finding of guilt and placed you on probation for a period of 3 years and ordered a $2,000 fine. That was because you had an agreement with the state, and that was their recommendation. During your period of probation, the state has filed a motion to adjudicate, and they have alleged in looks like 8 separate counts, ways that they're alleging that you have violated your probation. And so you've had an opportunity to review that with Mr. Manning. And so I would ask you at this time, how do you plead to counts 1 through 8 contained in the state's motion to adjudicate and revoke?
True.
Are you pleading true to each one of those counts because each one of those counts, those things that are being alleged is in fact true?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead true to any of these counts?
Yes, sir.
Okay. Court will accept the defendant's pleas of true. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection, Judge.
All right. Then court will accept his judicial confession, and the court will find that based on the evidence that Mr. Damon Jacob Gutierrez has violated the terms and conditions of his community supervision. Court will follow the plea agreement reached. Court hereby adjudicates his guilt, convicts him of the third-degree felony offense of possession of controlled substance. The court revokes his community supervision, assesses his punishment at 3 years confinement. The Texas Department of Criminal Justice Institutional Division orders him to pay the balance of his financial obligations and awards him 179 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Gutierrez, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Step over to Deputy Everett to be fingerprinted. Who's next, Mr. Manning?
Judge, I have D'Anthony Smith.
D'Anthony Smith, CR 21144. And what are the terms of that plea, Mr. Manning?
Judge, this is similar in the same charge as Mr. Gutierrez, and that it's a possession PG 1.4 grams. Originally put on probation August 24th of 2021. It's a third-degree felony. Upon a plea of true, state's motion to adjudicate, defendant's guilt is going to be adjudicated and community supervision revoked. Punishment assessed at 3 years TDCJ, institutional vision with the balance of financial obligations. The fine on that is $3,500, restitution $180, court cost is $20, and reimbursement $105. Mr. Smith has 109 day credit. and the sentence will run concurrently with any and all other charges.
On the credit time, did you say 109 days?
That's correct, Judge.
Okay. And does your client waive the formal reading of the state's motion to adjudicate and revoke?
He does. We've gone over it multiple times.
All right, Mr. Smith, sir, if you'll raise your right hand, I'm going to place you under oath. Mr. Smith, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
So I do.
All right, thank you, Mr. Smith. You can lower your hand. All right, Mr. Smith, you appeared before the court on September 28th of 2021. You pled guilty to the offense of possession of a controlled substance, penalty group 1 gram to 4 grams of third-degree felony. Court heard the evidence that day, found that there was enough evidence to convict you, but the court followed a plea agreement that you reached with the state. The court deferred a finding of guilt and placed you on community supervision or probation for a period of 6 years and ordered you to pay a $3,500 fine. It's been during your period of community supervision that the state has filed its motion to adjudicate and revoke community supervision, and they have alleged in 14 separate counts ways that they are alleging that you violated your conditions of community supervision. Have you had enough time to review this document with your attorney, Mr. Manning? I'm sorry, I couldn't hear you.
Yes, sir.
Okay, and do you feel like that you understand everything that you've read and signed today?
Yes, sir.
Is there anything about the paperwork that you don't understand or that you need clarification on?
I'm sorry. I understand everything.
Okay, and are you pleased with Mr. Manning as your attorney?
Yes, I am.
Mr. Manning, do you believe Mr. Smith to be competent to enter into this agreement?
He is, Judge.
All right, then, Mr. Smith, how do you plead to counts 1 through 14? Are those counts true or not true?
True.
And are you telling me that each one of those counts are true because in fact what is alleged is true? You're not just saying that to get a certain plea agreement?
Sir, it's true.
All right, Mr. Smith. Court will accept the defendant's plea of truth to each count. Mr. Manning, any objection to the defendant's waiver of rights and plea of truth being admitted in evidence?
No objection, Judge.
If that's admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we rest in close.
Anything further from the defense, Mr. Manning?
Judge, I had an opportunity to talk to Mr. Smith about this case, and he wants to assure the court that this is the last time you're going to be seeing him. He says he's getting too old for this. He's got a daughter that's going through some health issues. He wants to be there for her, and so I think I believe him in that situation. I think he's ready to get his life turned around. I think this trip will be down there. He'll get some life skills and be able to come out, be able to work, and be a positive member of society.
And thank you, Mr. Manning. I'm glad to hear that, Mr. Smith, and I hope the same for you and for your daughter and for your family, okay?
Yes, sir. Thank you, Your Honor.
You're very welcome. All right, then, based on the evidence, the court finds that Mr. Smith has violated the terms and conditions of his community supervision. The court will follow the plea agreement between the state and the defense. Court hereby adjudicates the guilt and convicts Mr. Smith of possession of controlled substance, penalty group penalty group 1 gram to 4 grams, a third-degree felony. The court revokes his community supervision, assesses his punishment at 3 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay the balance of his financial obligations, and awards him 109 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Smith, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'll have you go with Deputy Everett to be fingerprinted, and good luck to you, sir.
Thank you, Your Honor.
You're very welcome. Mr. Manning?
Yes, Judge. Next I've got Miss Toon, Savannah Toon.
All right, Savannah Michelle Toon, CR 2231. Go ahead, Mr. Manning.
Judge, state and defense have reached an agreement in which Ms. Toon agrees to submit herself voluntarily to a treatment facility in Kaufman County. The information of that is private because it is a protected site, but I provided that information to both the state and to the probation department. She'll be released tomorrow and be headed directly there. And as a condition of probation, she must successfully complete their program, which is between a 6-month and 1-year program, which focuses on giving her the skills and tools to become a good, healthy parent. She is 6 months pregnant as we speak. And so trying to equip her with those tools, life skills, drug classes, all the things that we need to have done for probation. She'll also be getting in a safe environment.
All right, and this plea agreement was in consultation with the probation department, and they're fully supportive of it?
That's
Yes, Your
correct.
Honor. And I spoke with Ms. Stark from the probation department earlier. She has spoken with the facility that is administering this program. She was very impressed and called to tell me that. So we believe that this is going to be a good placement for Ms. Toon.
Okay. And Ms. Toon, you understand that the court is very concerned about the health of your baby right now, considering actions that you've already taken that will affect this baby leading up to our hearing today. You understand that you may have already done things regarding possession or consumption of controlled substances and things that could affect the health of your baby. You understand that?
Yes, Your Honor.
And you understand that I got a great concern about that. And so if I approve this and you do not take it serious, you leave that facility or you do anything, then there's a good chance that you might not see your baby for a long time. You understand that?
Yes, Your Honor.
So this has got to be of the utmost importance to you, because this decision not only affects you, but it also affects that child that you're carrying.
Yes, Your Honor.
Okay. All right, then the court will, and that's going to be a motion to withdraw, amend, to continue. Is that correct?
Yes, Your Honor.
All right,
And
is that already filed, or is it going to be filed?
It's going to be filed. I asked Miss Abney to email it to Miss Matura at the jail to be submitted with the rest of the paperwork.
Ms. Burns has that, and my client has signed the amendments to her probation.
Okay, then the court will approve and grant the motion to withdraw to amend Ms. Toon's community supervision conditions to submit herself to the drug rehab facility there in Kaufman County, as indicated in the amendment. The court will sign that to allow Ms. Toon to begin that rehabilitation as soon as possible.
Yes, Judge. Thank you, Judge.
All right, you're welcome.
Judge, next I have Mr. Briggs. Judge, we're here on arraignment today. I've gone over the indictment with my client. He understands the charge against him. His name is spelled correctly. He understands the range of punishment. At this time, he pleads not guilty and requests to be set on the trial docket.
All right, court will find that Braden Lee Briggs in CR 23-7 has waived the formal requirements of arraignment. Court will set Mr. Briggs for pretrial hearing. You want to set that April 6th, Mr. Manning?
Is that a Thursday, Judge?
Yes, that is a Thursday. The only other Thursday I have is March 9th, and that doesn't give you a whole lot of time.
Judge, if we can, I'm coordinating with Mr. Briggs' attorney in another county. So if we can have a little bit more time, that would be appreciated.
All right, court sets Mr. Briggs for pretrial hearing on April 6th. And Mr. Briggs, your court hearings will be at 1:30 if you're in custody. If you ever make bail in this case, and your hearings will be at 9 a.m. at the courthouse.
Last but not least, Judge, I believe I have Mr. Corey Thomas.
Mr. Thomas, CR 16-69 and CR 19-123. Motions to revoke. Go ahead, Mr. Manning.
Yes, Judge. I have received an offer from the state, and I've been in contact with Mr. Thomas's family. I'm seeking to get mitigating evidence to provide to the state, and I would request an additional reset for us to be able to gather that information and provide to the state.
Okay. Court will grant Mr. Thomas a final hearing on his motion to revoke. We'll set that March 30th at 1:30.
Judge, I believe that concludes my business. May I be excused?
Yes, thank you, Mr. Manning, and I would like to note for the record, it is 2:05 p.m.
Thank you, Judge.
You're welcome. We'll see you, man. All right, Ms. Thompson, I need just one moment. I'll be right with you. Just stay where you're at. Take just a second.
You tell him. Yeah, you said 246.
All right, Ms. Thompson, are you ready on Ms. Crisp?
We are, Mr. Chris.
All right, for the record, this is cause number CR 22-209, CR 22-210, CR 22-211, State versus Amber Nicole Crisp. Believe that we are set for plea today. Ms. Crisp, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right.
Yep.
All right, thank you. You can lower your hand. Just speak up for me, okay? All right, Ms. Crisp, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
You can put your hand down. All right. And Ms. Crisp, have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Ms. Thompson. Are you pleased with Ms. Thompson's representation of you?
Yes, sir.
All right, and you've signed some paperwork today. Do you have any questions about any of that paperwork?
No, sir.
All right, you understand everything that you've read and signed,
Yes, sir.
and where you've signed, you're telling me that that's your true and correct signature. Is that correct?
Correct.
All right. And Ms. Thompson, do you believe Ms. Crisp to be competent today to enter into this plea agreement?
Yes, sir, she's competent.
Have you explained to her her legal rights as they pertain to this case and the other cases that she's been charged with?
I have, yeah.
And do you believe that she's entering into this plea intentionally, knowingly, and voluntarily?
She is doing that, yeah.
All right. Ms. Crisp, you are charged by indictment with a third-degree felony offense of intoxication assault with a vehicle causing serious bodily injury. A third-degree felony offense carries a range of punishment of not less than 2 years or more than 10 years confinement in prison and a fine not to exceed $10,000. I see that the plea agreement with regard to that charge is that you would plead guilty in exchange for the state's recommendation that your punishment be assessed at 5 years in prison with a $1,500 fine plus court costs, $290 plus restitution of $240 plus reimbursement fees of $35. And the state would be dismissing an accident involving serious bodily injury case, a criminal trespass, and a possession of controlled substance, all within this plea. Is that your understanding of the plea agreement, Ms. Crisp?
Yes, sir.
That's what you're asking the court to approve today?
Yes, sir.
All right, understanding the plea agreement, understanding the range of punishment. Ms. Crisp, how do you plead to the third-degree felony offense of intoxication assault with a vehicle causes serious bodily injury?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, court will accept the defendant's plea of guilt. Ms. Thompson, any objection to the state's evidence? All right, there being no objection, states exhibit 1, stipulation of evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just that the state is in compliance with victim notification. We don't have anything from the victim to present to the court at this time. However, we have had contact with the victim through their civil attorneys to make them aware of the plea that was happening today.
Thank you, Ms. Heisel. Anything further from the defense, Ms. Thompson?
No, Your Honor, we'll rest you close.
All right, thank you. Court's going to review the evidence briefly.
That kind of explanation.
All right, Ms. Heisel, just going through the state's exhibits here. What is the evidence of the serious bodily injury? I may have just overlooked that.
Your Honor, let me pull up my case notes. I believe that the victim alleged in the indictment had multiple broken bones as well as lacerations to her liver and spleen. To my recollection, those required surgery, but I couldn't be certain of that, Your Honor, but that's my recollection off the top of my head. And I'm not sure that would be contained in State's Exhibit 1, Your Honor. We do have additional medical records that information was obtained through.
Yeah, I don't see it in States 1. The court believes it would be necessary for that to be in the plea to support a serious bodily injury plea. Ms. Thompson, you've reviewed the evidence on behalf of the defendant, is that correct?
That's correct, Your Honor.
And this evidence that Ms. Heisel is reporting exists regarding the bodily injury, you've reviewed that on behalf of Ms. Chris.
I reviewed the medical reports and it substantiates what she says. There was surgery that did, I can't remember which it was that had the surgery, but both sustained broken bones. And I believe the lady did have the surgery, but I'm not positive on that.
Okay, then Ms. Heisel, what I would like for the state to do is submit State's Exhibit 2, which we could seal if it contains any confidential or private medical information. We can seal that for purposes of the record. If there's no objections from the defense to State's Exhibit 2, medical records to support the SPI.
And Judge, there is a single page that shows a list of the injury sustained to her. I believe that I could submit that to the court under seal because there is identifying information of the victim on there without submitting the very voluminous health records, I think that would substantiate the claim made by the state.
That would be fine. I just need something in the record that way if this goes up on review, there's something to prove SBI. So if you believe that's sufficient, then submit that as State's Exhibit 2. Court will admit that without objection from Ms. Thompson. And the court will order that to be sealed.
Thank you.
All right, then, based on the evidence reviewed by the court and the statement given by Ms. Heisel, the officer of the court finds that there is sufficient evidence to convict Ms. Crisp of this offense. The court will follow the plea agreement reached between the state and the defense. Court hereby convicts Amber Nicole Crisp of intoxication and assault with a vehicle causes serious bodily injury. Court will find that a deadly weapon was used, however, not a firearm. The court assesses her punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division, orders her to pay a $1,500 fine, $290 court cost, $240 restitution, $35 reimbursement fees. The court dismisses under section 1245 CR 22-210 accident involving serious bodily injury, 2020-288 criminal trespass, and CR 22-211 possession of controlled substance, penalty group 1, less than 1 gram. Court awards Ms. Crisp 45 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Crisp, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'll have you go with the deputy to be fingerprinted. You'll be taken into custody.
Yeah, the police bug business, may I be excused?
Yes, thank you, Ms. Thompson.
All right.
That's everything for today. So. All right, court's going to call cause number CR 21-59 State versus Ashley Bay Dover. Ms. Dover was set this morning at 9 a.m. She's appeared. Court's going to withdraw the judgment nisi and alias capias. Any announcements on the motion to revoke, Mr. Schmidt?
Judge, we received an offer from the state yesterday. I think we need some additional time to negotiate. We asked this to be reset. This is our first, second setting. I was planning second day. This first since that.
All right, court will grant an additional hearing on the motion to revoke. Court sets Ms. Dover for March 30th. And that will be at 9 a.m. So if you're out of jail, your hearings will be in the morning at 9 a.m. every time. If you're in jail, then it's always at 1:30. Ms. Dover, remember, you're still on probation. So just because they file a motion doesn't mean that you don't report, you don't drug test. You still need to do all those things. If you have any more violations, the state can always amend their motion against you and add additional things. So it's very important that you stay in compliance with your probation and follow the advice of your attorney, Mr. Springer. Okay. You're welcome. So right here. So we'll take care of you. Deputy Everett, are you still over at the jail?
Yes, sir.
Hey, can you do us a favor? And there's a individual over there that needs extradition. His name is Joseph Eric Taylor. Joseph Eric Taylor. Can you have him brought up so I can do the extradition?
Sure.
Judge, I believe that's all the business the state has. May we be excused?
Yes, sir. You may be excused. Appreciate you.
And
Thank you, Your
Judge,
Honor.
I see Miss Taberham just walked in front of you. I emailed States Exhibit 2 on Miss Crisp to Miss Taberham.
Great. Thank you very much. We'll get that printed out and put it with the papers and I'll make sure it gets it.
Thank you, Judge.
All right. Thank you. Y'all have a good day.
Okay, so
Mr. Taylor? Sir. Judge Rick. Judge, I'm Mr. Taylor here when you're ready.
All right, just one second.
You can have a seat. Sir, you can have a seat until the call, just you don't have to just stand there. All right, big. See your home screen. You show that, listen to it all day. Is that the one that keeps the door too? Yeah. Wow. Oh, they were just here a minute ago. I think they were just here a minute ago. It's pretty good, yeah, for a long time.